SJC-13210, Katharine Armstrong and others, v. Kathleen Theorides and others.
Okay, Attorney Sanders is up first.
Good morning. May it please the court, Dylan Sanders for the Commonwealth of Massachusetts. I will focus my time on the first issue that has been reported for appeal concerning the Department of Environmental Protection's authority to rely upon harbor-specific standards approved in a municipal harbor plan. I am, of course, happy to answer questions about the second issue concerning CLF's cross-appeal, but otherwise we will rest on our brief for that issue. There are three independent grounds on which this court can and should reverse the Superior Court's decision below and find that DEP has authority from the legislature to adopt those provisions of the waterways regulations that incorporate and indeed rely on and require the department to rely on harbor-specific substitute standards that have been approved by the Secretary of Energy and Environmental Affairs when the department is making licensing determinations for non-water dependent uses in areas of tideland, non-water dependent uses of tidelands in areas subject to an approved MHP. Those three grounds are as follows. First, Chapter 91, Section 18 alone provides the department with sufficient authority to design a regulatory system that relies upon harbor-specific standards that have been approved by the Secretary, applying traditional principles of judicial review of administrative regulations.
I'm trying to understand the limits to that. Could the department just pass a reg saying whatever the Secretary says goes?
No, Your Honor, and
So-
that's not the case that we are presented here.
Well, but
The department-
why not? I'm just trying to make sure, because one thing I can't figure out is what residual authority does DEP actually retain? And, you know, particularly, I take it the municipal harbor plan, this one, it deals with the big enchiladas, the height of the building.
Among other things.
But it could have done everything, right? It could have included in the municipal harbor plan all the different aspects that DEP considers, couldn't it?
Municipal harbor plans cannot displace all of the performance standards, indeed any of the performance standards, and I'll explain.
Why not? Well, why not? I'm just trying to understand.
So what the substitute standards are minimal standards that are applied to project-specific uses of tidelands. They get a specific project in the Chapter 91 system. They are not the performance standards themselves, and they should not be confused with the performance standards themselves, which the department subsequently uses in making its licensing determinations. And this was at the heart of the Superior Court's decision below. The Superior Court equated, and indeed appellees are quick to equate, the satisfaction of a substitute standard with the satisfaction of the performance standards that the department uses in making licensing determinations for specific uses. Those are not the same two things. If I can convince you of one thing here this morning.
Well, I understand they're not exactly the same in this case, but could they be? Could the municipal harbor plan expand beyond height and deal with all the different things that DEP is looking at? That was my question.
So the generic standards that are otherwise in the waterways regulations, the 8 generic standards that can theoretically, that are open to the Secretary to approve if they've been proposed by the local municipality.
So they could use all 8 then? They could put all 8 into the municipal harbor plan?
Yes, so those 8 include setbacks, footprint, height, the width of the harbor walk, and other elements. Those are not to be confused with the 3 overall performance standards that DEP later uses when making licensing determinations about specific uses. Those overall performance standards are in 9.51, 9.52, and a 9.53, the first paragraph of each of those. Those are the performance standards that a project must satisfy in order for DEP to later determine, after an extensive Chapter 91 process, that the project is worthy of a license. But the MHP process itself and the substitute provision, the substitute alternatives themselves do not take the place of those performance standards.
So, apply those here. Give me a specific, tell me how that would apply here. So Municipal Harbor Plan has said you can build a 600-foot skyscraper here, and you can build a 300-foot whatever.
If I may stop you there, Your Honor, the Municipal Harbor Plan approved here does not say, it does not authorize the construction of a 600-foot building. What it says is a building up to 600 feet is the new, in this case, maximum standard for that. That project still must meet, in the context, it still must meet all of the other criteria.
Give me an example, and also it would help me. Has there ever been a time where the DEP rejected a project that had been approved in a Municipal Harbor Plan? I mean, or has it always been sort of, if it got into the Municipal Harbor Plan, it eventually was licensed by DEP? Has there ever been an example, and could you flesh that out for us?
Yes, so I am not aware, and there's certainly nothing in the record of DEP having approved a specific project that complied with a Municipal Harbor Plan.
No,
However,
I'm asking for the opposite, where they've decided, for 30 years this has been going on.
Correct.
Has DEP ever said, this was in the Municipal Harbor Plan, but I still reject it? Or is it every... I don't give the license. This was included in the Municipal Harbor Plan, but a license didn't issue.
So I don't have a specific example to give you, and there's certainly none in the record. DEP certainly reserves the authority to deny a license or issue a written determination that a license is not warranted for a specific use, even if a project complies with an alternative standard. So in this case, even if a specific project is 585 feet, nevertheless, DEP still reserves the authority to determine that it does not meet the overall performance.
Is that true in the real world? Put aside the delegation here for a moment. Is that last point true in the real world, where you've got the secretary who has made the decision to hire the commissioner of DEP, and DEP is there, for better or worse, in less of a political position and more of in a regulatory position, where they have an enormous obligation when you're dealing with the tidelands. So the reality of the Secretariat and the agency and the Secretariat's relationship to the governor, in the real world, is that ever going to happen?
Let me answer, Your Honor. In the real world, I take your points. They are all valid points. But also in the real world, extensive work goes on in the approval of the Municipal Harbor Plan. In the real world, the Secretary, and in reality, the obligation has been delegated by the Secretary lawfully to the Office of Coastal Zone Management. In the real world, CZM works closely in the development process with DEP. So as you see in the record, and as well as in the amicus briefs that have been filed in the appendix of the amicus briefs of the Mass Municipal Association, DEP routinely and often concurs after extensive involvement in the development of the Municipal Harbor Plan process. So there is extensive administrative work, detailed work that goes on. That, I would submit, is an important point to take from the real world as well. If I may continue there with...
Before you do continue, my question is this: how do I distinguish between what you're calling reasonable, rational reliance on the secretary versus delegation that's improper under the public trust doctrine?
Excellent question, Your Honor.
Thank you.
The distinction is this. Municipal harbor plans are a separate process. They are started by a municipality who proposes to CZM and the secretary that they want harbor-specific standards governing the tidelands for that particular municipality. After an extensive process that includes public comment, that involves and consultation with DEP and other agencies, a public hearing process. If the secretary approves the MHP, then the MHP goes into effect with one or more up to 8 substitute standards. The Chapter 91 process, that sets the table for the Chapter 91 licensing project. If a particular project then wants to go forward under those new guidelines or in some places their requirements of that municipal harbor plan, the Chapter 91 applicant then proposes to DEP, and they have to go through, by the way, local zoning before they get to that, and they have to go through all other environmental avenues before they get to that. But let's say they get through all of those processes. Then the application lands on DEP's desk, and then the Chapter 91 process starts. There's public notice, there's a new public comment period about the specific project, and there's public hearings if it's a non-water dependent use, and then DEP, following extensive, actually, discussions and negotiations with stakeholders, issues a written determination. That written determination is where DEP makes the determination that the project's benefits to the public interest in tidelands outweighs the project's detriments to the public's interest in tidelands. That crucial determination, which DEP is charged with making under Chapter 91, Section 18, is nowhere made by the Secretary in the approval of an MHP. If there is one thing that I want to convince Your Honors of, or attempt to convince Your Honors of today, it is that no such delegation has occurred because the department...
Then tell me, if that's the case, tell me why shall means may. So if you take 9.312B, DEP shall apply use limitations on the numerical standards specified in the municipal harbor plan as a substitute for respective limitations contained in the DEP waterway regulations.
I'm here to tell you, Your Honor, something different. Shall does not mean may in that context. I'm here to tell you the state defendant's position is that shall means shall. But the follow-up question should be, if I may presume, well, what is the department binding itself to do? The department, by binding itself, and this was part of the error the Superior Court made below, by binding itself to applying those alternative standards, the department is not binding itself to saying that in any public purpose determination, I'm using public purpose determination here to refer to the balancing test of benefits versus detriments to the public's interest in tidelands. All the approval of a substitute standard does is redefine the envelope of potential projects that are eligible for a Chapter 91 license. It does not bind the department in any way to find that a specific use of tidelands, after considering the entire project in its totality, under all the performance standards, and indeed under all the other standards of the waterways regulation, the department's decision to bind itself to alternative minimum standards, indeed the department's decision to bind itself to the generic standards that are in the waterways regulation, does not bind the department to then determine that every project that meets those requirements is eligible for a license. It works the same way if the Secretary had never approved an alternative standard. The fact that a project meets even the generic standards in a waterways regulations does not mean it gets a Chapter 91 license.
Would be really helpful if you could actually give me an example in 30 years where that actually did occur. You know, so it really, the municipal harbor plan changes a couple of specifications, but otherwise DEP is completely free to make their licensing determination based on the generic standards. Is that right? So that when I read the AG's brief, which says you need to read shall as may to make this legal, they're confused too. Everybody's confused because this is really pretty simple. They're just substituting they're substituting a couple of factors, but otherwise DEP can freely do its job. Is that right? Because when we go through this enormous record and deal with this, is that going to be the ultimate conclusion here, or are you oversimplifying that they really are occupying most of the decision-making here?
I think what the AG's brief did, and what the Superior Court decision did below, and what Appellee's argument does, is they don't properly place the role of those generic standards, or if there is a substitute standard, what role those play. Those define the envelope of potential projects that then DEP can consider.
They not just define the envelope, right? They're saying that because this building is as high as 600 feet, that shouldn't impact your decision-making, right? Is that what they're saying, or am I overstating that? When the secretary says you can have a building as high as 600 feet, can DEP then use the size of that building, the height of that building at all? Or is that, they've lost the ability to consider that factor?
Oh, excellent question, Your Honor, and I
Not
take
as
your
good as
point, too.
Justice Wendland's,
Yeah.
but
And that gets to the heart of it. Yes, DEP, so the Secretary has approved an alternative height standard up to 600 feet. That's a new envelope. It comes with offsets, which are intended to offset. DEP nevertheless consider that in the context of considering all other factors that it needs. Wouldn't DEP, and it would be the same in applying a generic standard. The fact that a building, a structure, a use of tidelands is 55 feet, due to peculiar circumstances of that particular lot, that might be, it might have adverse impacts that DEP would take into account in making the public benefit versus private detriments calculation.
they can do that consistent with DEP's regulation, which defers to the secretary on that point? They can still ignore it or discount it?
Neither, Your Honor. Under the regulations, DEP reserves the ultimate authority to make that determination about whether it's eligible for a license under the standard in Chapter 91, Section 18. As a practical matter, getting back to your Honor's point, there has been and will be often extensive administrative record concerning that is fodder for DEP. And as a practical matter, all parties, both those who oppose and those who are in favor of the project, will take that into account. But the critical factor is this. All the approval of a substitute standard does is redefine the envelope which defines the projects which are eligible for a Chapter 91 license.
Let's say that's true. What you're going to hear is it doesn't matter. Let's go back to the initial delegation. And Chapter 91, Section 18 just does not allow DEP to delegate this responsibility to the secretary, even if it's advisory. So you go to step one, the initial delegation of the legislation. That's going to be their initial argument, I think.
And my initial argument is that there has been no delegation because the Secretary's approval of a municipal harbor plan and any substitute standards in it is in no way a determination of whether the public benefit, a project's benefits to the public's interest in those particular tidelands outweighs the detriments. So the Secretary's approval of substitute standards, again, is not that public purpose determination. Those are two separate processes, those are two separate animals, and the proper public purpose determination can only be made in the context of a specific use that applies for a Chapter 91 license.
So can I, let's say I'm the department, and the secretary has approved a building 600 feet high. Can I say in my overall analysis, 600 feet high, because it's 600 feet high, I'm rejecting it? Is that consistent with the
I'm
regs?
sorry, I missed the tail end of Your Honor's question.
So I'm the department, and I'm going through my Section 18 responsibilities, right?
Correct.
I have an application, somebody's building something 600 feet high, consistent with the municipal harbor plan. Can I say, everything else looks good, but it's 600 feet high, I'm rejecting it?
Theoretically, yes. A specific project, so to begin with, the Secretary has not authorized any particular building to go up to 600 feet. So the department evaluates a specific project, which the Secretary has not done. The Secretary has established an envelope, and the written determination we have here, the approval of the municipal harbor plan is very clear. They are not authorizing any specific project or the height of any specific project. They are merely establishing a new standard for that municipal harbor
All
plan.
right, so whatever they're doing, let's say, use your words, they're establishing a new standard. Can I say, as a department now, that standard, I don't like it, reject the project based on that new standard that the Secretary has set?
The Department of Environmental Protection always has an obligation to protect the public's interest in tidelands. This is an obligation that can never be altered by the Secretary's of approval of a alternative standard or the Secretary's approval of all 8 alternative standards. And this is crystal clear as a matter of law in 310 CMR 9.35, which says that every project or any project must be consistent with those rights that the Commonwealth holds in trust, those rights in tidelands that the Commonwealth holds in trust for the public. So the department always has the authority to rule, and 3.9.35 is not subject to alteration or compromise, or it's not impacted by the Secretary's approval of substitute standards. It is what's known as a basic requirement. Basic requirements under the waterways regulations overcome a presumption that a project otherwise meets the public purpose requirement. So if the department believes that, nevertheless believes.
Well, I don't understand the presumption point, because I thought you were saying there's no presumption, that DEP always has the ability to make the statutory finding it needs to make. But there is this presumption, right, in 9.312, right? There are presumptions that come with the municipal harbor plan. Is that right?
Not quite, Your Honor.
Go ahead.
But you put your question puts the finger on the right presumption. 9.312 says the department shall presume if it satisfies the performance requirements in 9.51, 9.52, and 9.53. It shall presume.
What are those? Are those, again, I can't keep all these numbers straight. When you say if it satisfies those, are those the municipal harbor plan or the opposite?
Excellent. No, they are neither.
Neither. That's helpful.
9.51, 9.52, and 9.53 contain the 3 performance standards under the waterways regulation under which the department assesses whether a specific use of tidelands.
Let me ask a more pointed question. Is there a presumption created by a municipal harbor plan?
No.
There is none. And so when we go through all these, when all those law clerks go through these massive number of regulations, they're not going to find any presumption of public purpose associated with the municipal harbor plan.
Correct. The department, so.
Because then I'm a little confused by the brief, the amicus brief that's filed by, I think it's the former commissioners, or that says DEP could rebut the presumption of the project serving a proper public purpose. So, and to, so long as to prevent overriding detriment to the public interest. I'm confused where these presumptions are coming from.
So, if I may explain, Your Honor.
Yeah, go ahead, because this is hard.
9.51, 9.52, and 9.53 are the three overall performance standards that the department has set forth in the waterways regulations. 9.51 it said a project, to paraphrase, must conserve the ability of the tidelands capacity for water-dependent uses. 9.52 says that those particular tidelands must utilize the shoreline for water-dependent uses. 9.53 says that if it involves Commonwealth tidelands, those particular Commonwealth tidelands, that's a definition, must be activated year-round for public use. Each of those performance standards contain the generic provisions. Let's set aside the alternative standards for a moment.
Yeah, but I don't want you to do that, because for us to boil this down, we're trying to understand how much weight the Secretary's approval of the municipal harbor plan plays in this process. Because the legislature clearly thought DEP, they're the number crunchers. They're the environmental protectors to the legislature in many ways. And they clearly thought they were going to sign off on this thing. And something has been ceded to the Secretary. How much, I can't discern, because the briefs are, albeit all terrific, are complicating this for me. From what I get from what you're saying is the Secretary's enhances what can be considered, but doesn't in any way change what DEP does. That doesn't seem right to me, but I can't put my finger on why that's not the case.
So it's incumbent upon the court to parse the regulations carefully. Let's stick with the performance standards the performance standard in 9.51 to conserve the.
I want you to focus on the Secretary's. Is there any deference owed to the Secretary? Is the Secretary just, basically, sitting there like an obelisk with no effect on DEP?
No, absolutely not. So the Secretary's approval of an alternative standard for a specific harbor area changes that particular standard, which is otherwise a generic standard, changes that particular standard for the purposes of determining whether projects in that municipal harbor plan are eligible for a license. That's the legal effect of it. Now, as a practical matter, a lot of work goes into determining whether it is
I get the part that a lot of thought goes into municipal harbor plans, but as Justice Wendland asked earlier, okay, so you find the Secretary says 600 feet is eligible. Can the DEP still say, well, 600 is eligible, but I still don't like it? I don't think they can, right?
The Department of Environmental Protection does not parse projects in that particular way when it gets to licensing determination. It looks at specific applications for specific uses of tidelands in their totality. Every aspect.
Right, and everything about it is okay. I love the plan, the project is great, but it's 600 feet. That's why I'm rejecting it. Can I do that if I'm the department?
If you have a good basis in the record for doing so, you find that you
So
find
even though
that,
the regulations say shall waive, I can still say, I love everything about this plan, it's great for the waterways, it's consistent with my public trust, but 600 feet is just too much, I reject it.
well, it's never going to be consistent, the department's never going to say it's inconsistent with the public trust, because the department can't say that. So that is the ultimate backstop the department
I
has.
use a 600-foot redefined standard as the basis for a rejection.
Let me put it this way. Too tall, if it meets either the generic standard of 55 feet or any alternative standard, too tall is simply never a standard that DEP applies. They apply the overall standard of whether the public benefits to the specific project in those tidelands outweigh the public detriments. If
Well,
DEP,
can't the height be one of those public detriments?
absolutely. Simply, yes.
So it can be, but if the secretary has said 600 feet is good, can I then, as a department, say, no, it's not?
The department just doesn't go about the overall public benefit determination, the weighing of the entire benefits of a
But that's what
project.
gets to my earlier question, which is the municipal harbor plan can jump in on other factors too, right? There's no limitation on how many of those factors the secretary can waive, right?
Well, there are 8, and the way the secretary has to weigh in on them is cabined and guided and curtailed by the regulations.
It's guided by the political process and and it has to be in the municipal harbor plan, but give me another factor. Pick one, just give me one.
Setback.
Okay, can the municipal harbor plan say, I waive the setback in that place? Because, there's a walkway that goes the other way around it. Can I waive that one? Can the municipal harbor plan waive that?
And
Yes
you
or
miss
no?
all sorts of,
Start
yes,
with a yes or no and then qualify.
yes.
Okay.
What does that mean then?
Mm-hmm.
That means that a project which,
Give me another one. Give me a different one. So we got setback, height. Give me a different one.
overall footprint.
Okay, overall footprint. Can the municipal harbor plan blow that provision up too? Yes.
I will not accept the premise that it's called blowing it up.
True enough. My bad choice of words. Can it-
Increase the envelope.
Yes,
So it can do all of those things,
in 8 defined ways.
Under a different standard.
but then doesn't that raise an issue of whether DEP is being taken out of the primary regulatory role if the municipal harbor plan can take over each one of those factors? I'm not saying it's a bad thing. I'm not saying it's not good policy to have coastal management and the city and everyone else involved. I'm just not sure that's what the legislature had in mind.
To be clear, let's go back to what the legislature, the only conditions that the legislature posed to DEP when it gave DEP the authority to promulgate regulations and design the regulatory system was that DEP make the ultimate written determination about whether the public benefits of a specific use in tidelands outweighed the detriments.
But the legislature did not do what DEP did, which is create a regulation that allowed the municipal harbor plan to waive particular aspects of this. DEP did that itself.
So
Or the secretary called the head of the DEP and said, let's draft up regulations that do this, right?
So again, I'm seeking to persuade you that what the secretary approves, when the secretary approves alternative standards for a municipal harbor plan, is not the equivalent of what the legislature has charged the department with.
But isn't it a practical equivalent? I mean, I know you're doing your best to try to thread this needle, but if in DEP's ultimate analysis of whether or not the pros outweigh the cons, that they look at it and all of a sudden, they just miraculously find that you can go from 55 feet to 600? They just miraculously find that we can waive the setback to whatever the municipal harbor plan? It's all, isn't it all in the same stew? You can recast what DEP's doing, but you can subsume everything that is found in the MHP, can't you?
No, Your Honor.
Well, you can't put the height variance for up to 600 feet into DEP's calculus of whether the pros outweigh the cons?
Oh, I'm sorry, then I may have misunderstood your question. Absolutely.
Sure, and if you go back to Justice Kafka's other criteria, setback. If the MHP says, you know what, in this particular case, we're going to waive the generic provisions and we're going to find that you can build right up until the water line. And then all of a sudden, when DEP goes to do their pros and cons, say, you know what? It's going to be to the public benefit and outweigh the detriment to go right up into the water line. Isn't that what we're afraid of? Isn't that what the concern is here? That it just becomes a fait accompli when it comes out of the MHP.
I understand that's the fear. I'm here to convince you that it's not. When the Secretary approves an MHP, after an extensive public process, they set alternative standards. Those are not standards that the DEP uses in making its public benefit determination. They are only standards which determine which projects are even eligible for a Chapter 91 license in the first place. Under the generic standards, if a project is 56 feet, it never hits DEP's desk. And the question is the same when the Secretary approves an alternative standard. If the alternative standard for the harbor garage site is 601 feet, it never hits the department's desk. As long as it's under 600 feet, then it goes into the Chapter 91 licensing system, or a specific use goes into that Chapter 91 licensing system. Then DEP has reserved for itself the ultimate authority to determine under Chapter 91, Section 18, whether the public benefits to the tidelands outweighs the public detriments to the tidelands. I get it that there has been an extensive administrative record that's been developed around the pros and cons of 600 feet. That's all for the department's fodder. That's all for any potential challenge to a particular project. That can be used, but and DEP will use that information, that administrative record, in making the ultimate determination about whether it's eligible for a license. But the Secretary's approval of an alternative standard is not a de facto public benefit determination. It doesn't make any particular use of those tidelands that meets those standards a fait accompli or a rubber stamp. There is an extensive Chapter 91 process that looks at all aspects of that specific use.
Thank you. We're going to move on to Attorney Pyle.
May it please the court, Jeffrey Pyle for Katharine Armstrong and the other Harbor Towers parties. I'll be splitting my time with Mr. Shelley here today. In Chapter 91, the legislature delegated its sovereign power over the tidelands to DEP. I think we all agree the DEP does not have the statutory authority to subdelegate that power to anyone else, including the Secretary. That is what has happened here. And the Secretary does not have a delegated authority to act to regulate structures in tidelands or to make the required statutory findings that the legislature has assigned to DEP in Chapter 91, Section 18.
Why are they making the determination as opposed to, if you look at the regulation, providing guidance?
These municipal harbor plans do not provide guidance, Your Honor. They say repeatedly in Section 9.34 and 9.51 that DEP shall apply these substitute dimensional requirements in assessing any Chapter 91 license. It shall apply the substitute lot coverage and open space determinations by the Secretary, shall apply the Secretary's decisions about distance from the shore, shall apply the Secretary's decisions about pedestrian access, shall apply its determinations about interior and exterior public space, and shall apply the Secretary's determinations about building height. There is nothing in this regulatory scheme that makes a municipal harbor plan mere guidance. There is nothing that makes it advisory.
So, counsel, if I understand opposing counsel's argument, I think what he's saying, through the envelope analogy, is that all the secretary's doing is creating the new gate, right? So there's a default that DEP had, let's say 55 feet, but the secretary is just going to say, well, you can apply if you're 600 feet. It doesn't mean that you're going to get licensed, but we're just going to increase that gate, you know, whether it's the setback or the height or the footprint. You know, the secretary is going to give you a new number, a new numerical standard. And that doesn't mean that each project gets approved by DEP. It just opens the doors to maybe more projects, consistent with whatever the secretary has determined is consistent with the harbor plan. So why is that an improper delegation? It doesn't give any project a license. It just opens the doors a bit consistent with the secretary's judgment.
One of the core things that Chapter 91, Section 18 requires the department to do is to make a determination that a particular project serves a proper public purpose and also will bring about a net public benefit, a greater public benefit to the public than a detriment to the public in terms of its access to the tidelands. And I direct Your Honor's attention to Section 9.312 of the regulations, which say that the DEP shall make these proper public purpose determinations, and then goes on to say the department shall presume that the proper public purpose determination, quote, is met if the project is a non-water dependent use that complies with 9.51, which includes municipal harbor plan substitutions. So in other words, the department must, under these regulations, presume that this statutory standard is met if a project conforms to a secretary's dimensional substitutions in a municipal harbor plan. That is not guidance. That is a tying of hands of the DEP in making its discretionary determination.
I mean, it would be a tying of hands if it said the department must approve. I mean, it sounds like it's just a presumption based on, you know, a rational judgment, one might say, that this extensive process described by your opposing counsel ended up with something that was, you know, proper.
Yes, Your Honor, but there's more.
Okay.
The regulation provides that the presumption may only be rebutted in extremely narrow circumstances that have nothing to do with the protection of public lands, these tidelands, for public uses of recreation, fishing, fowling, navigation. It says in 9.313, it says the presumptions may only be overcome if the basic requirements of 9.31 have not been met, which include things like the building code, and a clear showing is made by a municipal, state, regional, or federal agency that other requirements are needed to prevent overriding detriment to a public interest. These are extremely narrow circumstances under which these presumptions can be rebutted. And they cannot notably be rebutted by a private aggrieved person.
Isn't that standard inconsistent with what DEP's statutory standard is supposed to be, which is, when you add these presumptions, this overriding detriment seems to be inconsistent with the regular finding they're supposed to make, right, under the statute about benefits versus detriments?
Yes, Your Honor. That is the crux of our argument.
Say you're right. We also have 30 years of title problems out here. Is this a prospective rule? The AG tries to get us out of this. If you're correct, I take it, you know, we're unsettling the title of a huge amount of property in the Commonwealth. just a gigantic amount, unless this rule is prospective. Address that a little bit.
Well,
We tend to not like to have rules that have been in place for 30 years that haven't been challenged, and then all the building on the harbors and most of the cities in Massachusetts are suddenly going to be under a cloud. So how do we deal with that, if you're right?
Well, Your Honor, number one, I'd say it's important to remember that this is the legislature's delegation of authority here. The legislature can retroactively decide that all the previous municipal harbor plans are okay in its view. It can-
I don't think we want to count on that. So why don't you, how do we address the problem that if you're correct, should this rule be a prospective rule or a retroactive rule? And, because that's a significant problem here. The AG suggests that in the property context, this should be prospective. Do you agree with their analysis?
Your Honor, I've reviewed their analysis and the cases they rely on, and I cannot say that I agree with it necessarily, because that analysis relies on cases that have to do with a new interpretation of a statute based on where the court has reversed its prior rulings on the meaning of a statute. That isn't the case here. What we have here is an ultra-virus regulation that was invalid when it was enacted. In the Moot case, this court faced the same issue. The Moot 1 court was looking at this regulation that exempted landlocked tidelands from all licensing, and it decided that that the regulations were invalid and ultra-virus, much as we're asking the court to do today. One of the things that the Moot court did—
That was a much narrower problem, right? That was non-water dependent. I can't remember, but Moot was, we're talking about everything approved pursuant to municipal harbor plans.
Well, Your Honor, actually, I think the Moot decision was pretty, was an earthquake in Thailand's law, because there were structures that had been built without Chapter 91 licenses in reliance on the regulatory exemption. And suddenly there's a building that needs a Chapter 91 license and doesn't have it. And that is, frankly, a greater problem than what we're dealing with
But
here
I don't know
today.
about that. This seems like higher on the Richter scale as far as an earthquake. And I guess that you've got something like 17 plans over the course of 30 years. There's been no challenge. There's financing in place. No one's questioning title issues. Why is it that the decision couldn't be prospective, if you're right?
Well, Your Honor, but certainly speaking for my clients here who have the specific issue with—
How about the statute of limitations? Would there be a statute of limitations?
Yes, Your Honor, we understand that, in fact, there is a statute of limitations on a challenge to a Chapter 91 license, that is 30 days. And so anybody who has been granted a Chapter 91 license under these old municipal harbor plans, anybody who has had an opportunity to challenge those, including by raising the issues we're raising before you today, has long since lost that opportunity. And the briefing that from amici raised this specter of clouds on title, but none of them have really articulated with specificity just how this issue would harm them in the future,
again,
especially where there is no—
So I don't know if you're a property lawyer or not, but so the statute of limitations is expired, but the permit should not have been issued. Does that affect your title? How does that work?
Your Honor, I don't have a view on whether that affects title prospectively. All I've looked at is the briefs of groups like NAOP and others who have this issue well in mind, and none have explained just how this would affect title. There is a licensure issue at stake at most.
So how does NAOP address the title issue? Do they address it at all? I can't remember. I've read a bunch of these amicus briefs.
For the most part, my memory of the NAOP brief is that it mostly echoes what the state defendants argue about the merits, but then goes on to say this would affect a lot of municipal harbor plans and a lot of other landowners and people who have relied on these Chapter 91 licenses under MHPs in the past. And we certainly agree that I would be concerned if I was one of those title holders, but and certainly, we cannot necessarily assume that the legislature will come in, but the legislature did come in after Moot. The legislature came in after the Moot 1 decision and decided, this regulation has been struck down. We need to act in order to provide certainty to people who have built structures on land that now have tidelands, and the fact that there might need to be a legislative fix has not, in the past, I believe, dissuaded this court from declaring what the law is. Whether or not this can be prospective, I simply don't see a prospective ruling that is supported in the court's precedents on prospective rulings in the past. Typically, the court declares what the law is at the time the decision is made.
If we can go backwards for a minute, let's say that you're right about DEP from the legislation, Chapter 91, Section 18. They have the responsibility. They have the public trust in the tidelands. They have the ultimate licensing determination. But why isn't it that they cannot delegate to the Secretary with Coastal Zone Management Assistance a part of the evaluation and even incorporate a different standard to assist them in performing that obligation? In other words, why isn't this a reasonable delegation from the initial statutory framework?
For two main reasons, Your Honor. One is that Section 18 of Chapter 91 precludes it. It says the department shall make the determination. But beyond that, the legislature has never authorized the Secretary to act to protect the public trust in tidelands through making dimensional determinations or anything else. And if there's one thing that's clear from 200 years of law from this court, it is that there must be an express delegation of authority to a person or entity to act to protect the public trust in the tidelands. And there is no such statute granting that to the Secretary that anybody has pointed to.
What do we make of the provision that makes the Secretary the administrator of the tidelands?
Section 18B of Chapter 91. Section 18B of Chapter 91, again, came about as a result of the Moot 1 decision, and it gave the Secretary a particular limited role. The Secretary shall make public benefit determinations of tidelands projects, including those within landlocked tidelands, and its actions shall not affect anything else under this chapter, meaning Chapter 91, or under the regulations. And it shall not delay the DEP's issuance of a Chapter 91 license. The legislature could not have been clearer in Section 18B that the Secretary's sole role was to make a public benefit determination that goes into the record of the DEP licensing decision, but does not otherwise impact it unless the DEP decides to, in its own discretion, to take something into consideration that the Secretary said. The legislature knows how to delegate explicit tidelands regulatory authority to other entities. It has done so in a number of different statutes. The case law is replete with examples where it has done so.
The Alliance for Nantucket Harbor case, Nantucket Sound case, I think is an example where there's an explicit delegation.
Yes, and that is an example where the legislature said that the Energy Facility Siting Boards shall issue a permit that shall be a composite of all permits that would otherwise be required to license a particular structure in the tidelands. And the court ruled that that included a Chapter 91 license in that case because the project was proposed for the tidelands. But that is very different from Section 18B, which simply says that the Secretary can issue a public benefit determination that goes into the record. And in fact, another example was raised by the former secretaries in Chapter 21A, Section 4C, about oceans development. This other statute that applies to water-based areas far outside of harbors. The Secretary is given expressly in that statute, passed in 2008, authority to act to protect the public trust, but it doesn't extend to the tidelands. The tidelands is ruled by DEP in Section 18. The legislature knows how to delegate the public trust authority to the Secretary and to anybody else. It has not done so in Section 18B.
Now, the awareness issue, one of the briefs suggests the legislature's been sort of informed of these regulations, at least indirectly. How do we address that? That, you know, I know there's this sort of legal fiction about their omniscience, but they have been presented, these regulations, in different forms, right?
The regulations, we are led to believe, were submitted to the legislative entities, the committees that the statute requires them to be submitted to. All we would say to that is that all that would suggest is acquiescence by silence. And what the court requires is express delegation of authority, and express, a tacit acceptance is the opposite of express. Express is required under this court's prior precedents, and simply allowing regulations to go into effect without, by the way, seeing the underlying municipal harbor plan regulations. We have no indication that that 901 CMR 23 at all was sent up to the legislature, so they didn't necessarily know what the secretary was doing there. But regardless of that, tacit acceptance is not express approval.
Any other questions? Great, thank you very much.
Thank you.
Okay, Attorney Shelley.
Madam Chief Justice, members of the court, Peter Shelley representing the CLF plaintiffs in this appeal. I have so many thoughts. I think this is really actually a pretty straightforward case. Was the secretary acting to further public trust rights in tidelands by what he approved in the alternative standards in the MHP? And if he was acting to further public trust rights, was he expressly authorized to do so? As my colleague said, there is, several hundred years of sort of consistent, never challenged case law in the Commonwealth, going back to the inhabitants of the Commonwealth versus the inhabitants of Charlestown in 1822, that says you have to have express authority whenever you're acting to further public trust rights. Clearly, the secretary thought he was acting to further public trust rights. It's throughout the municipal harbor plan decision. And despite hundreds of papers and, addendum after addendum, not one person has cited to one piece of legislation that says that the secretary is authorized to exercise any authority in the context of DEP's licensing jurisdiction. And that's exactly what's happening here. Justice Wendland, your question about the 600 feet, it's an exaggeration. We at CLF had just many problems with the Harbor Garage site, which had 3 exemption substitutes rather than 600. But that's a perfect example. In that case, when a developer comes in, it's not just a building envelope. It's maybe useful to think of these as zoning, in the zoning context. It's not a good metaphor completely, but there are zoning standards, and they set the table, as my brother said, for what can happen in a particular district. And then in the zoning context, usually there's a variance procedure that's set up by law that you can go up to a higher authority and get a variance from the standards that are set by the zoning code. The same, more or less, system is happening here. DEP has promulgated specific meets and bounds and heights and distances and widths that it says meet the proper public purposes established by those 3 performance standards that my brother referenced.
What do we do with the fact that, I take it municipal harbor plans are also authorized by the legislature, right?
No, the legislature never even heard of a municipal harbor plan, as far as I know.
So municipal harbor plans are totally the creation of they don't have any statutory authority whatsoever? Now, CZM has statutory authority, I assume, right?
CZM has statutory authority to implement the Massachusetts Coastal Zone Management Program, the federal.
And the Coastal Zone Management Program doesn't expressly, it's all by regulation, how it integrates into the municipal harbor plans? There's no statutory intersection whatsoever.
It doesn't, those regulations don't even really talk about the municipal harbor plan. They look at other coastal zone management issues, not these licensing
So the municipal
measures.
harbor plan, the whole origin of it is basically a political process giving the cities more say over how their, development, where does it?
Well, as you said,
where does it?
it's not a bad idea.
No, it's certainly not a bad idea.
Not a bad idea. It's just not authorized in its current form.
It's authorized only by regulation then?
Only by regulation.
And only
When-
by DEP regulation or also by CZM regulation and?
By both. There's
Okay.
a set of EOEA regulations that lay out the procedures for how the secretary is going to make the determinations that they make under the Municipal Harbor Plan. And in the DEP regulations, there are references to the fact that there is this harbor plan that will be used to modify various provisions in DEP regulations. When those regulations were sent to the legislature for whatever weight that carried back in 1990, the Municipal Harbor Plan regulations that really define what the secretary's role are were not even promulgated yet. When you look at the transmission letter that's in the file that DEP sent to the legislature, they acknowledged that they hadn't even developed the MHP program through the
But
rulemaking process.
That's not going to be dispositive, though. The fact that the legislation doesn't say municipal harbor plan isn't dispositive.
I agree.
What we're trying to figure out is whether or not the statute authorizes DEP to be able to look to the secretary for their take on this issue through the prism of a different standard when they're making their licensing determination and doing their job as it relates to the public trust in tidelands. So does the statute allow DEP to authorize the secretary to chime in like this?
The statute does not expressly authorize that. You know, there really is no basis in the law for having that mechanism there in a binding capacity. There are provisions in the MHP program that are advisory. They're called amplifications, or they're different phrases where the secretary can suggest, can provide guidance, which is what I think Your Honor is talking about, guidance to DEP. And it says DEP should take that into consideration when it's issuing a license. We're not talking about those provisions, and Judge Davis was not talking about those provisions. He was talking about the 600-foot rule that said, isn't guidance, it's you have to approve, if everything else is satisfactory under your regulations, and the only issue is, should there be a 600-foot building there instead of the 55-foot building that DEP regulations would allow, is that legitimate? And, you know, the answer to that's no. So, you know, that's just not authorized anywhere to have the secretary bind DEP like that. And to make the point of how bound DEP is.
If it weren't a public trust case, is it because it's a tidelands case that this regulation is an improper delegation? Could DEP do this somewhere else? I mean, tidelands, you all three of you are arguing, it requires very express authorization and empowerment provisions. But could DEP do this elsewhere and sort of kick some of its responsibilities to the secretary if it weren't a tidelands case? Would it be an improper delegation otherwise?
I think it depends on the particular statute in mind, but I would say probably yes.
Probably could. So it's a narrower. It's just
you know, it's really this case law that has called out this particular sovereign power that the legislature has that can only be exercised through a delegation that's expressed by anybody, a municipality, the secretary, DEP. They all could do that.
Is there anything in the legislative history that explains why DEP has been given, I mean, I have recollections from old state government fights that, you know, DEP is sort of the tiger in this area, but is there anything in the legislative history that explains, look, we really want DEP doing this, DEP's special expertise in environmental, or anything, is there, when we go through the legislative history on this, which seems to be there's more than usual, are we going to find anything?
The only two things I think you'll find are the Senate bill that was considered in the opinions of the justices case, which was a Tidelands case. And in that bill, the justices were asked whether or not a law that gave the Secretary of Environmental Affairs authority to relinquish or take other actions with respect to tidelands was could be done, could be enacted legitimately with the passed law. And the court said, yes, you could do that. You could certainly designate and delegate that power to the secretary. They did not do that, however. When they passed Chapter 91, just a year or two later than that Senate bill was on the floor, the secretary is nowhere to be seen. In fact, the second time you'll find the secretary pop up is in the legislation around Section 18B, which was added after moot. And there, the legislature said, the secretary has these powers under the public benefit determination, but the secretary's jurisdiction there has nothing to do with DEP's licensing jurisdiction. And at the time, the secretary adopted regulations implementing that public benefit authority that it had been given. And in the secretary's own interpretations promulgated at the time, it said that nothing that the secretary is going to do under this public benefit determination is going to have any impact, impair in any way DEP's licensing jurisdiction. So I think the only instances you'll find, Your Honor, are ones where the legislature has been quite specific in what it has done, and it has not decided to move toward the secretary as having any authority to further public tidelands interests.
When you say that it binds DEP, it doesn't bind DEP. DEP still could, in the face of all of this, say, well, no, we've got the ultimate licensing responsibility, and we're not going to license this. And I think the legislative history question that Justice Kafka is asking goes along with, has this ever happened in 30 years? Is there anything in the legislative history that recognizes how challenging that would be for DEP to do?
Challenging to
say, well, we're going to license anyway.
Ignore the secretary in those circumstances?
We're going to license this anyway. I know what you've said, Madam Secretary, but we're going to license this anyway. Is there anything in the legislative history? Because it's not true that DEP is bound. DEP has the licensing determination under the statute. They can say no.
Not as to that particular measure in the performance standards. And if that's not clear in the DEP regulations themselves, which, notwithstanding the Attorney General's brief, says shall so many times that it's hard to believe that it was a may. But beyond that, if you look at the decisions by the Office of Alternative Dispute Resolution, OADR, there are two cases, the Van Pier case and the Wynn case that went before, that were appealed, where licenses were appealed. And the people challenging the license wanted to raise the height issue. Said, well, what about the height issue? We don't like the height that DEP approved in that license. And the administrative officer at DEP and the commissioner approving the decision said, height is not on the table in any challenge to a DEP license. That is the secretary's rule. DEP did not make that rule. That 600 foot was not promulgated under DEP's authority. There is no basis for challenging it in an appeal of the license. So not only DEP, but the public is completely bound by the secretary's decision and has really no right of judicial review of it. Other than this, I suppose.
Are there any other questions? Okay, thank you.
Thank you, Your Honor.